Yes, counsel. Good morning.
Good morning, Your Honors. If it please the Court, my name is Maurice Reedy. I represent Mr. McDonald, the petitioner in this case. First, Mr. McDonald and I both thank you for accepting his application. It was frustrating not to be able to argue this case before the appeals court. The Commonwealth, in this case, has asked the courts to expand the scope of the criminal harassment statute to include a pattern of conduct directed at a person's house and at their pets. Basically, Mr. McDonald was convicted of the crime of criminal harassment by driving down the street.
Well, there was more to it than that, wasn't there?
Essentially, no.
Driving down the street, staring at someone, taking pictures.
The testimony. Oh, I was going to add one thing, and also taking photographs of big dogs that were in someone's front yard. There was testimony that he was looking at and staring at the house. Nowhere in the trial transcript was there any statement or evidence or implication that Mr. McDonald was looking at or staring at any children, Mrs. Hart, Mr. Hart, any people whatsoever. Every time Mrs. Hart said he was looking, she said twice, I think it was page 43, he's looking at the house. This whole thing started, a neighbor, it's sort of like neighborhood crime watch gone out of control. It began, innocently enough, by him stopping to take photographs of these huge dogs who were in the front yard of a house with no collars and no fence. And a neighbor saw him do that.
What about the fact that the police officer said, you know, I can't stop you, but you would be well advised, essentially, not to go back to the street, and he says, yes, I'm not going to do that anymore, and then does.
Yes, well advised. Not only did the officer admit on cross-examination that he had no authority to order Mr. McDonald not to drive down the street.
Well, I didn't say it was ordered.
No, this was a suggestion. However, the only flaw that I could find in trial counsel's defense was that he failed to distinguish between the two aspects of this, one, driving a truck down the street, and two, taking photographs. I believe that Mr. McDonald's actions indicate that he was really sorry to have freaked out this woman, and that he based it on the fact that he was taking photographs, in which he said, his testimony, which was not credited at all by the trial court, was that he was absolutely not going to take any more photographs, and he didn't. But to assume the alternative, and that was that merely to drive down the street, even if, and we don't concede that, but even if he drove down the street in order or in violation of what he considered to be that, it still doesn't violate the first element of the crime. That conduct has to be directed at a person.
Well,
and the fact that he was told...
But he said, I'm sorry, tell the people I'm sorry, I won't go back there and do it again. And then this is like Cape Fear. This guy's, he knows exactly what the psychological effect is going to be on these people, and he goes back.
That was the point. He didn't.
He didn't go back?
No, he went back.
Yeah.
Because to assume that what the officer was talking about was simply driving by this woman's house, which the bus driver testified that he had been doing for at a minimum of 4 months, every day. No one saw him. He did nothing but continue to do what he'd been doing, what he said was, for years. There are two ways to look at this case. One is mechanically with the elements. As I said, this conduct cannot be stretched to have been directed at a person. But then there's the other way to look at this.
Well, why can't it be? I mean, he knows...
Because
he knows that she's upset about it because they went to the police and he said, I'm sorry and I won't do it again. So he knows they're upset about it. Maybe he's just having some fun with this. But the effect of it wasn't funny at all.
No, I agree. Her distress was amply recorded in the trial. It was just to assume that it was the fact that he was driving by among hundreds of other people, which he'd been doing for months, to no effect.
He's driving by at precisely the time the kids get off the school bus. He's seen in the last time, I think it was, or the next to the last time, outside the back of his car, right in front of a school bus stop, just before they get home?
That was, unless the trial...
He's not doing it for the effect?
Unless the trial court discounted every single thing he said. He began by saying, I get out of work at 3, my wife gets out of work at 4, I kill that hour. I do the same thing. I drive around with my camera. This is America. We fought and died to be able to do this. So he does nothing more than that all the time, every day. The bus driver says she sees him constantly. It was no surprise that the neighbor kept seeing him because he does it. To have the police come to his house and say, you're freaking this lady out, I have to assume that he thought the police officer meant the photos, which he never did. He never stopped again, except when the neighbor yelled at him.
Isn't that a question of fact, though? Isn't it up to the jury to decide whether this guy, he was essentially on notice of the effect that this was having on people, and he went back and orchestrated it, continued to repeat to do it, because he knew what the effect was going to be?
Again, an orchestration by driving down the road.
Isn't that a question of fact?
No, Your Honor.
The jury could not have inferred that that was his intent, to instill fear in his people by bizarre conduct?
Based on the fact that he had been doing it for 4 months and all he did was continue to do it? And he stopped.
Yeah, based on that.
He stopped taking pictures.
All of a sudden it went from innocent conduct to something where he knew what the effect was on these people, and it was intentional. The jury couldn't infer that?
I don't think so, Your Honor.
Did I understand that at one point he was staring at someone?
The only time the words staring or stared occurred in the transcript was when this neighbor said that he drove by slowly. I mean, the image that gets created is incredibly misleading. Slowly. As if someone was rolling by the house, looking sideways out their window. He happens to drive by during that hour when the bus stops. You know how when a school bus stops, it comes and goes, there's traffic behind. I'm sure that there were days when he was ahead of the bus. It was the image that was created was malevolence. This neighbor said he was staring at the house. Actually, once he said staring at her, once he said staring at the house. Those are the only
Once he said staring at her?
I believe he did. Okay. While we're on the subject of staring, unless someone is going, there was no testimony as to how fast he was going. Unless someone is going 1 or 2 miles an hour, it is extremely dangerous, if not impossible, to stare at a fixed object as you're driving by it. To stare means more than a glance. He's driving by. How does one stare at someone? I think staring is just more charged adjectives to add to it.
Now, was there any evidence that he had ever seen her before or knew her name until the police spoke to him about her?
None whatsoever, Your Honor.
So the only time in which there's any evidence that he even knew who she was when the police spoke to her and mentioned that this lady, Mrs. Hart.
He had no idea who she was.
Did the
and
police,
in fact,
did the
that
police
would
give a name or an address or not?
No.
So what did the police tell her? The police officer didn't say this lady, Mrs. Hart, is upset about you?
No, there's someone on
On the street, wasn't it?
Yes.
People on the street?
So
there's somebody on that street. He didn't identify her, didn't know which house it was.
So when was there any evidence that he saw her? Was it when she
testified
stopped
that
him?
after her neighbor told her about this truck, then the next day, like he does every day, there he goes by. He wasn't looking then. Oh, no, I'm sorry, I stand corrected. She did say he was looking at the house. Now, she's standing in the driveway. Why wouldn't she say he's looking at me? If this was directed at her, why wouldn't he be? That's why I wanted to address the fact that there are 4 or 5 cases I cite in my brief. I think 3 decided by the appeals court and 2 by this. Every single one of those cases, they paint the picture of a defendant orchestrating, to use the court's word, a pattern of conduct directed unmistakably at one person, following the person. I think the first one was the defendant went to 2 places of the victim's employment, 2 different offices. One, the worst one, I think, was Robinson. The defendant sat at the bar where she worked as a server, followed her out to the parking lot, She was shopping in a mall and looked across, and there he was. She's coming out of the drive-thru and looks in her mirror, and there he is. Every one of the cases paint that picture. This one cannot be fit into that box. This is a guy driving down the street, and he had been doing it for months.
Now going back, so you're saying that on May 15th, when she calls to him and says, what are you doing, is the first time that there's any evidence that he saw her or knew that she was the complainant?
I can't remember his exact testimony, but at some point, I think he realized where this was happening. And his testimony, again, the trial court was free to disregard some or all. It's not clear how much she discounted. But he testified that he was driving by and he heard, "Hey, you," and thought, maybe I can just stop and just say, "Excuse me, I'm so sorry. I didn't mean to freak you out. I'll never do it again," meaning the photographs. But so he stopped against his better judgment. The neighbor comes up to his window, and I think his words were, he decided to have a chat with Mr. McDonald. Mr. McDonald said he couldn't get a word in edgewise. This neighbor was just basically berating, "Don't you ever do this. You're going to have a problem if you do this anymore." And Mrs. Hart testified that she was ill. She got nauseous at that moment. This is a fellow who, he stopped because they yelled. He didn't stop to sort of like up the ante. This was him, a normal person, realizing that some gross misunderstanding, and he was sorry that she felt so bad, and figured in his naivete that he could stop and with a few words make it go away. "This is me, I'm not a bad man, I'm sorry," And it backfired, clearly. That was the only time they ever came near each other. There was some coincidental conduct months later in the line at a grocery store, which was...
But he wasn't charged. I mean, that
was irrelevant. That was coincidental.
Everything that's part of the
That
charge
was
was
pure
in May,
coincidence.
right?
This is a mix, and that's the problem with this. They're asking the courts to expand. This is a stalking statute. This has to do with people singling out someone and surreptitiously following them and bothering them. This is not that. This is Mr. McDonald driving home from work.
I thought the neighbor testified, and trust me, I have not read the transcript. I'm really just looking at the briefs. I thought the neighbor testified that she had seen his van parked at least twice right across the street from the victim's home.
That's correct.
And also had seen it parked a little down the street, and she then next saw the van driving on the street, and she got the license plate number. So these are 4 occasions of him being right there. That's what alerted the victim here to the problem. And she went to the police.
Thank you.
Is that the sequence?
A careful reading of the transcript indicates that there were 2 instances where Mr. McDonald was parked. He admitted that twice on 2 different occasions. He parked across the street from her in front of this neighbor's house to take pictures of the dogs across the street. The second 2 times, that neighbor testified, "I saw him twice parked, and I saw him twice on the road." Those words by the neighbor were transmuted by the Commonwealth and by the appeals court in their 128 ruling to parked. It's page 19, I believe, of the transcript. She says, "He was parked twice. The first time I came out, and just as I got there, he drove away." Who knows whether he even saw her. He took his photos and left. And obviously that's used to characterize, here's someone's coming, I better take off. Everything is painted with this suspicious brush. And if you subtract that painting, it's a fellow
Well, we have to look at the
innocently.
whole painting, as does the jury. So you've got this, he's alerted to the problem, and on May 11th, he drives by when the school bus is there, right, slowly, and the victim sees him. Then, a few minutes later, he comes around and drives by again, slowly, looking at the house. She sees that as well. The next day, the same thing. The next day, she sees him parked in front of the school bus, getting out of his car. I mean, so this is the whole picture.
Right, again, there's more of his testimony that the trial judge didn't credit. He was that last time you mentioned he was parked. he was looking at a lawnmower for sale. Now there was either more of his fabrication of why, this was a quarter of a mile away from Mrs. Hart's house now, so I don't know how that could be. I didn't even want to bother that one. Essentially, that's the crux of it, Your Honor, and I appreciate your allowance.
Thank you, sir.
Thank you.
Thank you.
Good morning, Your Honors. Audrey Anderson Kate Shore for the Commonwealth. If it pleases the court. The Commonwealth's evidence was sufficient to prove that the defendant willfully and maliciously engaged in a knowing pattern of conduct or series of acts over a period of time directed at Mrs. Hart, which seriously alarmed her and caused her, as it would any reasonable person, substantial emotional distress.
What's the evidence that it was directed at Mrs. Hart?
Mrs. Hart was the person that was in the driveway waiting for her children in her home. There was testimony that
May 11th.
she had been doing that since the middle of the school year.
She had never noticed him before that.
No, her husband or her neighbors would wait in the driveway for the children before then.
No, but when you said she had been doing that since the middle of the school year, but it wasn't till May 11th that she noticed him, is that correct?
Yes, Your Honor.
And that was after the neighbor. That was after the neighbor had alerted her that she had seen this person parked across the street.
The neighbor had alerted her that she'd seen him parked across the street twice, had seen him down the street once or twice, and at one time he raised the camera to take a picture, but the neighbor and a dog came outside, and
The picture of what? Not of her, not of Mrs.
she wasn't
Hart.
there. There was nothing there. There were no dogs.
And not of the house, was it?
He had the camera raised. The only thing there was a house. There was no person there.
Hart's house?
Yes, ma'am. To take a picture of Mrs. Hart's house. And when the neighbor and her dog came down the driveway, the dog barked. He was afraid, and he left.
Was there any photographic evidence? Were there pictures introduced of the dogs or the house?
There were pictures introduced of two dogs. I don't know when they were taken.
Well, what was the testimony about the pictures?
The defendant testified that he had taken pictures of the dogs. I don't know when he took the pictures of the dogs, but that he had taken pictures of the two dogs.
You said Mrs. Hart started to come out, but she didn't used to come out. She used to go to work, right, and be at work. She only came out after she became concerned.
No, in the middle of the school year.
I just don't know where
The middle of the school year, she started waiting for her children. And this is when the bus driver also noticed that the defendant would pass her twice on her route.
So any car could have driven past. I don't understand why the fact that a car drives past you means that you're being targeted.
Because the defendant didn't just drive past. People drive down the street on their way from work to lunch every day. The defendant drove by slowly, staring this way, made a loop, came back around the same way, driving slowly, staring.
This is which date?
This is May 11th, May 12th.
Okay, so
May 15th.
and so she believes that's targeted to her?
Yes,
Based on what? Because she's there?
Based on she's there, and he's driving by, and he is staring, and he's looking. Also from where she's been told by her neighbors that the defendant has been staring at her house and taking pictures of her house. There's also testimony but it wasn't explored, in the transcript that on May 8th, when her neighbor told her and her husband this, and they went to the police, that she was already aware of the defendant's behavior.
I'm sorry, that she was or he was?
That she was, she
Okay,
and her
but the
husband.
question is what is the basis to believe that he was targeting her, apart from the fact that he was driving by her numerous times and at one point stopped near her house? That's it?
Because she was home, she was in the yard, and he was staring.
She wasn't in the yard all 3 times, was she?
Yes, Your Honor.
May 11th, 12th, and 15th, she was there in the yard?
Yes, Your Honor.
Let's assume for a moment that the jury could have concluded that the defendant was directing these acts at the family rather than the spouse here, the wife. Would that be permissible to prosecute under the statute, or does it have to be one specific person as opposed to 3 people of the same family?
The statute says a specific person, but case law has shown where families have been involved. Commonwealth v. Robinson, Commonwealth v. O'Neill. In O'Neill, the father received letters. The daughter received letters from an inmate who was targeting his daughter. In Robinson, all the instances where the defendant was threatening the victim, except for one, his family was with him. So the victim is a person that is alarmed and that has the emotional distress, the substantial emotional distress.
So any member of the family, presumably, let's just assume that he had something against this family. And so he was driving by slowly and making a nuisance of himself. And anyone in the family would then qualify as a specific person that was being harassed?
That's a hard question to answer. I'm really not sure.
Okay. No, fair enough.
Well, I'm curious, going forward then, if someone gets a report of a person taking photographs of their home, is that enough to support a case? Photographs by themselves?
For harassment, Your Honor?
Yeah.
For harassment? No, Your Honor. I don't believe it.
All right, photographs plus driving by, is that enough?
No, Your Honor. The defendant was not just driving by. He was driving by and he was staring.
Oh, how about driving slowly by, as I do every day in the same place, and looking for a long time as I drive at this lovely yard. I admire how it grows. I do it every day. I stare at that house. Is that enough?
Your Honor, they're staring and they're staring.
And which one is this?
I believe it was staring.
Based on what in the
on
record
her-
distinguishes this staring from the, I assume, leering is what
Yes,
you
that's
mean?
Thank you, Your Honor.
Okay, and do we have, is the word leering
The
used?
word leering is not used. The
Okay,
word,
so we have staring.
we have staring. A reasonable person would not be upset if someone was slowly driving by looking at their Christmas decorations
Unless I didn't like the way they looked,
or looking at their flowers.
unless I didn't like their color or something else about them, or just got afraid because things like that happen, you know. Your neighbor says, he's staring. And you say, oh my gosh, he's staring.
He's staring, and the police told him that the neighbors at 75, in the area of 75 Meadowbrook Road, are afraid.
But-
That brought
but-
it up.
But somehow, suppose they just were afraid. But, you know, I mean, he was just driving by. It's his right to be able to be on the street. Why does he have to stop? Because somebody has said, well, we're afraid. I mean, he could just be, well, I don't want any trouble, so I won't do it anymore. But how does that establish the necessary state of mind that you need to establish? That just because he knew they were upset, he's supposed to stop?
I will, but
Well, but so
but
what?
I believe that the defendant's behavior was scary. It just wasn't driving down the street. These are these people's home. This is where they live. This is where you're supposed to feel safe. Someone is driving by not once in a day,
But there could be any number
twice,
of
staring
reasons
at
for
me.
doing that. Somebody could be driving by a house because they used to own it, and they miss it, and they just keep driving by it. And they want to look at it, see what you've done with it. They park across the street and they look at it. That's against the law?
No, Your Honor, that is not against the law. But when you look at everything that the defendant did, And when the defendant told the officers, "I'm sorry, I did not know that this was upsetting people. Please apologize to them for me. I will not do this again." And what does he do?
But he stopped taking the photographs.
The officer didn't talk to him about taking
What
photographs.
did the officer talk to him about?
The officer talked to him. He said that the people noticed that you are in the neighborhood hanging around when it's about time for the children to get off of school, and they are afraid. The defendant said, "I didn't realize that they were afraid. I was taking pictures of dogs. I will stop doing this. They will never see me again. Please apologize to them for me." That was Friday. What happens Monday? Monday, he drives by, he stares. Then he makes the loop. He does the same thing again. He drives by and he stares.
Well, you really seem to put a lot of emphasis on the staring. If he had driven by and not taken a look at the house, you have no problem with that. But the fact that he stared was, it seems that's the straw that broke the camel's back. He was staring. Let me ask you this question. So we want to give a rule to the general public on how to proceed in the future. So the rule would be, don't stare at anyone's house too often. Don't take pictures. And if the police advise you that you're causing distress for someone in a particular location, don't drive near that house. That's the rule? That sounds like what you're saying to us.
I'm not going to say that that's going to be the rule, Your Honor. That should be the rule. But what I'm saying is I am putting emphasis on the staring, because I drive down Belmont Street every day. If I drive down Belmont Street and I slowly drive by, stare,
You know, the word
again.
stare is so subjective, isn't it? I mean, how long is a stare? What goes? But I guess that's a question for another day. Well, please continue.
Your Honor, the behavior was just, it was scary. It was menacing.
You're basically saying it was creepy.
I don't want to say creepy, because what may be creepy to one person is not creepy to another person.
Ah.
So I don't want to say.
But they felt menaced. Nobody's questioning about it. And nobody's questioning the genuineness of their feelings. But the question is the reasonableness of that within the context of all of the circumstances.
Your Honor, from the circumstances, from the police speaking to the defendant twice, it wasn't just once. They spoke to the defendant twice about his behavior. He said that he would stop it. I know I keep saying he's driving down the street, but that's scary. And anyone can say, if you're scared, you're scared. Doing that twice and staring, it's scary and it's menacing. And Mrs. Hart was very, very afraid. And I believe that she should have been.
How old were her children?
I believe they were 7, 9, and 12.
And were there any other children that were dropped off by the school bus within, 5, 6, 7 houses of theirs?
There was one other child. The next door neighbor had a child that was dropped off also. Your Honor, I'm just want to state that the defendant's behavior was scary. It was willful. It was malicious. It was if he was playing a game. I think one of your honors said Cape Fear, and then I just thought about it was kind of like Cape Fear.
Yeah, except in Cape Fear, the person was the defense lawyer for the individual, and there was a motive to be taunting them. I gather we have no motive here.
We have no motive that is on record, but as in stalking cases and in harassment cases, sometimes there is no motive. There's just scary behavior. And in this world where there are all type of things happening, and it's just not normal for someone to engage in this type of behavior, especially when they've been warned by the police twice. They said they were going to stop it. They know it has upset the neighborhood, not just the Harts, the other neighbors, that he is upsetting. And he knows exactly where it is because the officer told him, 75 Meadowbrook Road. And basically, Your Honor, that's my argument. And thank you for your kind attention.
Thank you, counsel.